Welcome to This Explainer. I am your host, and today I need your absolute focus. We are not just looking at a dry academic syllabus here. We're decoding the very laws that govern our survival. These are the pillars of environmental law. So let's get straight to it. We have a packed docket today, and we're digesting an entire semester's worth of jurisprudence into one session. Part 1, the foundations of environmental law. Part 2, statutory and common law remedies. Part 3, constitutional rights and duties. And finally, Part 4, the international environmental regime. Section 1, the foundations of environmental law. India's ecological roots.
Let me state this right off the bat. Environmental consciousness is not some modern Western import. It is deeply, fundamentally rooted in our ancient Indian civilization. Take the beautiful concept of Vasudhaiva Kutumbakam. The world is one family. Environmental protection is mandated from our sacred Vedas all the way down to Emperor Ashoka's rock edicts in the 3rd century BC. I mean, millennia ago, Emperor Ashoka was actively prohibiting the killing of certain animals and legally mandating the planting of trees. We have been stewards of nature for thousands of years.
But how does the law actually define it today? Under Section 2A of the Environment Protection Act 1986, the environment comprises water, air, land, human beings, other living creatures, plants, microorganisms, and property. But I want you to mark this crucial word right here: interrelationship. It is an invisible web that connects us all. You break that web, and the whole system collapses.
Section 2, statutory and common law remedies. Our armor.
Okay, this is where it gets highly practical. How do citizens actually fight pollution? What are the legal mechanics at our disposal? Well, before modern statutes existed, victims relied entirely on common law torts. You had trespass, right? The direct physical entry of pollutants onto your property. Then nuisance, which is an unlawful interference with your enjoyment of land. Think of toxic smells or deafening noise. And negligence, basically a breach of the duty of care that causes pollution damage. These were the historic, traditional weapons of the common man.
But as rapid industrialization took hold, common law just wasn't enough. We needed a statutory shield, and Parliament stepped up. We got the Water Act in 1974, creating our vital pollution control boards, the Air Act in 1981 to strictly regulate emissions, the Environment Protection Act in 1986, our mighty umbrella legislation enacted post the tragic Bhopal gas disaster, and finally, the National Green Tribunal Act of 2010. This created a specialized court with immense power to award compensation and order environmental restoration. But remember, you have a strict 6-month limit to file your application.
So how do these laws apply in the courtroom? Let's use the FIRE Act method. Facts, issue, rule, application, conclusion. First, the landmark Church of God case regarding noise pollution. The facts. A church's loudspeakers were blasting continuously, exceeding permissible noise limits. The issue. Does Article 25, the fundamental right to religion, permit noise pollution? The Supreme Court's conclusion was an absolute no. Article 21, the right to life and a peaceful environment, always prevails. Your right to religion never overrides my fundamental right to peace in my own home.
Next up, the monumental MC Metha Ganja case. The facts. Tanneries were dumping toxic, untreated effluent straight into the holy river Ganja. The issue. Can the court use its writ jurisdiction to order the absolute closure of these major industries? Conclusion. Yes. And this brilliantly illustrates the polluter pays principle. The Supreme Court forced these polluting industries not just to shut down, but to heavily bear the financial cost of cleaning up. Put simply, if you pollute, you pay. Section 3. Constitutional rights and duties. The judicial sword.
We have now arrived at the absolute peak of Indian environmental jurisprudence. This is a place where our Supreme Court aggressively wields the Constitution like a literal sword to protect the ecology. Article 21 guarantees the right to life, but the Supreme Court expansively and powerfully interpreted this to include the right to a clean, healthy, and pollution-free environment. Mark my words on this. Article 21 is the beating heart of all environmental law in this country. Without it, the statutory frameworks are just paper.
Let's look at the Valour Citizens Welfare Forum case to see this in action. Facts. The Palar River and vast surrounding agricultural lands were being utterly poisoned by tanneries in Tamil Nadu. Issue. Can destructive industrial operations continue if they cause irreversible harm to public health? The court's conclusion? Absolutely not. They penalized the tanneries and ordered a green fund to be created from the fines to compensate victims and forcibly restore the environment.
Out of that Valour case came something incredibly powerful. The precautionary principle. By legal definition, where there is a threat of serious or irreversible damage, a lack of full scientific certainty cannot be used as an excuse to postpone measures. What does this actually mean in a court of law? It completely flips the script. It shifts the burden of proof. It is not up to the citizens to scientifically prove a factory is unsafe. The burden is entirely on the industry to prove that their operation is safe.
Then we have the MC Mehta Kamalnath case. Facts. Span motels encroached heavily on the floodplains of the Bias River, deliberately obstructing its natural flow. Issue. Can the state illegally lease public riparian land for private commercial use? Conclusion. The lease was unequivocally canceled, and the riverbed was ordered to be restored to its natural state. It sends a clear, unquestionable message. Not even a union minister's family can illegally usurp our public natural resources.
And that brings us right to the public trust doctrine. This is the law of the land. The state holds natural resources, our air, our water, our forests, purely as a trustee for the public benefit. They absolutely cannot be privatized. They cannot be sold off to the highest bidder. This doctrine imposes a strict constitutional obligation on the government, preventing them from alienating our ecological heritage for private commercial gain.
But what happens when an industry is inherently incredibly dangerous? In the MC Methaoleum gas leak case, highly toxic gas leaked from a hazardous industry right in the dense heart of Delhi. The issue, what is the exact liability of such hazardous enterprises? The Supreme Court took its most aggressive, uncompromising stance yet. Conclusion, absolute liability was established. No defenses allowed whatsoever.
So the crucial point is making sure we understand what absolute liability actually means in India. If an enterprise engages in a hazardous or inherently dangerous industry, it is strictly and absolutely liable for any damage it causes to the public. Unlike older English common law, which allowed exceptions, here there are zero excuses, zero defenses permitted. If you run a dangerous factory and it harms the people, you pay, period.
Section 4. The International Environmental Regime, the Global Shield. We must now zoom out from the national stage. Because consider this profound truth. Pollution does not respect international borders. Acid rain, ozone depletion, marine pollution, climate change. These monumental crises require a unified, binding global response. The legal bedrock here is transboundary liability. The Trail Smelter Arbitration of 1941 firmly established that no state has the right to permit its territory to be used to cause environmental injury to another state. And closer to home, look at the devastating 1984 Bhopal gas disaster, a U.S. multinational corporation causing massive, unprecedented damage in India. That proves exactly why we need robust international liability and corporate accountability frameworks. This global shield wasn't built overnight. It's a monumental timeline of pacts. It all truly started in 1972 with the Stockholm Declaration, formally proclaiming the human right to a healthy environment. Then 1992 brought us the Rio Declaration at the Earth Summit. In 1997, the world signed the Kyoto Protocol, leading all the way up to the historic 2015 Paris Agreement to combat climate change.
What is truly fascinating here is the shift in legal strategy between those last two agreements. The Kyoto Protocol of 1997 was a top-down approach. It placed strict, binding emission targets heavily on developed nations using cap-and-trade mechanisms. But the Paris Agreement of 2015 fundamentally changed the game. It is a bottom-up approach based on nationally determined contributions, or NDCs. It's a pledge and review framework where every country, including developing nations like India, sets its own targets to limit global temperature rise. And beyond just climate change, we have a vital network of major global conventions. The Ramsar Convention of 1971 protects wetlands of critical international importance. The Bond Convention of 1979 protects migratory species as they cross national borders. And the Convention on Biological Diversity from 1992 focuses on conservation and the fair, equitable sharing of genetic resources. India is a proud, active signatory to all of these, rigorously implementing them through strong domestic laws like the Biological Diversity Act of 22.
So we stand at a critical juncture. We have the constitutional sword, we have the statutory armor. The legal frameworks exist globally and domestically to protect our ecology. But here is the ultimate question. Do we have the fierce will to enforce intergenerational equity before time runs out? Will we aggressively preserve this earth for the next generation, or will we bankrupt their future? Think very carefully about that. Thank you for joining me for this explainer. I'll see you next time.